A landlord has a duty to repair that exists from the start of the lease and continues to the duration of the lease. Okay? They have a duty to keep the unit habitable. Okay? That covers proper heating and electrical systems. It also includes working plumbing, structural integrity, which is like the roof, the walls, the doors, the windows, functioning locks, freedom from pest infestation, functioning sanitary common areas, and some jurisdictions like California may require working stoves and refrigerators. See now, each state governs landlord-tenant law in their respective jurisdictions. But each state must adhere to the federal implied warranty of habitability. Okay? There is a federal implied warranty of habitability that applies to every residential lease in every state. Each state regulates that law. Okay? So they determine what the terms of that law is per their state, but let me make this, because I want to make sure I read this from the reference from the research that I did today, because there are specific points that I want to make. Here we go. The warranty of habitability cannot be waived in the lease. See, there are just certain aspects of a warranty of habitability that I don't believe people are aware of and are essential to you using it as a proper defensive tool. Okay, when living in a unit that is not habitable, where you have remedies to help get repair in a timely, reasonable manner. Okay, for instance, a tenant has a right upon breach of this warranty by a landlord to either withhold rent, repair and deduct the cost of repair from rent, or to terminate the lease. Now, those are three potential options depending on the circumstances. Under the circumstances, if you have sufficient circumstances, you may be able to withhold your rent. Okay, if you don't have heat. Okay, now, before we get to that part, before I even say before you have heat, there is another clause that we have to stress. Although you have the right to withhold rent, you may have the right to withhold rent, you may have the right to deduct the rent by the cost of repairs if you choose to repair it yourself. You may be able to terminate the lease irrespective of the term of the lease because of the condition of the unit, right? But this is only after proper notice of defect and allowing the landlord reasonable time to make the repairs. Now, reasonableness is highly subjective. And waivers and varies on how it is determined by state. But in cases of heat and power and basic essentials to live, okay, the sense of urgency will definitely be heavily weighed when determining reasonable time taken to make the repair. What else I want to tell you guys about this? Because what I want to stress is, no matter what the state law is concerning your leases and how they're regulated, okay? That's what I wanted to tell you. I got that written down here. I want to read it directly from here because I can say it from memory, but I want to make sure I say it exactly how I saw it. Hold on. Here we go. It is non-waivable. Okay? This implied warranty, this federal implied warranty of habitability, okay, which is present in residential leases in every jurisdiction, even if it is interpreted differently. This implied warranty of habitability cannot be waived and a duty is placed upon the landlord from the start of the lease for the full duration, the entire duration of the lease. Okay? So the warranty cannot be waived or removed by any provision in the lease agreement. Okay? So no matter what the lease says, you have this warranty. You understand? So what am I saying here? I saw some things where people had unlivable conditions, okay, where they should be taking measures to document these defects in the unit so that they can start considering their legal measures that they can take. Yes, this is an opportunity to have a consultation with legal counsel, okay, if it rises to that. But before that, you see a defect, right? Immediately document it, Okay? Immediately document it. The date, the time, and describe in detail the defect at hand. If you see evidence of a defect, document it. Okay? Immediately document. You need to keep a trail, a time, a record of the duration of the existence of this defect. Okay? Not only in the event that you need to write a notice to the landlord that you will withhold rent if this defect is not repaired within a reasonable time and it has made your unit inhabitable. Okay? And under the federal implied warranty of habitability, they have a duty to keep your unit habitable. And if not done within a reasonable time, you then can list what measures you may take, which could be, I'm going to withhold the rent until this repair is done. Okay? I have taken steps. I can take steps to repair myself and then deduct it from my rent. Or I am going to seek to terminate the lease. Now, and that's another point that came up that I want to make. You have retaliation protection. Generally, tenants are protected from eviction and penalties for reporting habitability violations to the federal government. Now, you can report those through HUD. Okay? But what I wanted to stress is that I feel that some folks may be under the impression that the federal implied warranty of habitability may only apply in HUD leases. Okay, and I wanted to clarify that it applies in HUD leases especially, but it also applies in residential leases and cannot be waived and is in place for the duration of the lease. Okay, also, just for further understanding the background about it, you know you got a warranty on a car, a warranty like on anything else. Okay, this is not a clause that is necessarily written into the lease. You do not have to read a lease and read a section that says you have an implied warranty of inhabitability. This is implied, meaning that it is not expressed, meaning that this is a warranty that exists in your lease but is not written in your lease. Even if it's not written in your lease, because it could be there, it may not be there. The moral of the story is the warranty is always implied where a lease is present. Residential lease, HUD lease, this implied warranty is applied. And that's what I want you to know. I want you to know that you have a right to live in a habitable unit. You have the right as a renter, a tenant, to live in a habitable space. The landlord has a duty to keep that unit livable, okay? And that can be enforced under the implied warranty of habitability and how it is interpreted through your state law. But it is also enforced through federal implied warranty of habitability. Let me give you a case. Let me give you the milestone case, because the milestone case is the one that will establish the federal level of the law. And I'm not certain. I'm going to do it. In Javins versus First National Realty Corp., and that's JAVINS, Javins versus First National Realty Corp., that case assured that a tenant's duty to pay rent is dependent upon the landlord's duty to provide a habitable home. Okay? That is the case law, that this ensures that in modern residential leases, a tenant's duty to pay rent is dependent upon the landlord's duty to provide a habitable home. Okay? I ain't show y'all that earlier. So, y'all know I like paper. Yeah, so I was all up in Google because I'm aware. I've studied this. I studied this in law school and I studied it, right? And so I'm aware of the warranty. And I saw some things in my FYP and I was like, I want to share background information about this warranty because I'm not certain if people are aware of it. People know that they can file complaints if they're discriminated against when trying to buy a home or rent. You know, they know that. You know, that's a little more pronounced. People are more educated about that. But I don't really see a lot of discussion about this implied federal warranty and how it's applied and how it works because it's not expressed, it's implied. So I just wanted to make sure that I express this implied warranty is in place, and that because of that, you have like ground to withhold your rent. How that's going to work though, and that's the next part, is you should be protected from eviction, meaning that a proceeding may, your landlord may try to press for a proceeding to evict. But when you go to that proceeding, you have your documentation to show that it's an inhabitable unit and you validly withheld your rent. Okay? So I hope that was informative. Now, what I was thinking and what I would like to do this week is work on maybe a template or two, some type of quick reference tool, some type of downloadable document. I want to consider what I can make and add to my resource tab so that you can download it possibly, potentially, and use that to write these things down and to keep for your records, maybe keep your own file, or keep it even on a soft drive, but like a template of sorts where you can start keeping record of the defects and the dates and the important details concerning these things that are needed for notice to your landlord in the event that you do want to take remedies that are available to you if they breach, right? Which means like you don't have power, you don't have running hot water, you don't have heat. These things are essential needs that make them in breach of the implied warranty of habitability and give you rise to take these options, right? So again, what I'm thinking is I'm going to type something up and put it on my resource tab, right? And then when I type something up, because I think that's something that'll be really useful and really helpful. Again, not only for you in the event when you need to do this notice to your landlord, okay, but also in the event that you may need to seek legal counsel. Because guess what? Even if you get an attorney, they still going to expect you to supply this information to them. They're not going to know. They're not going to know. They're going to want you to go sit down with someone. If not them, you're going to have a meeting with the lawyer to go over these details. If you have these details already ironed out, even if you have to seek legal counsel, that can reduce your legal costs, because it's going to reduce the time that they're going to need to put into preparation of any necessary documents that they may need to file. These will need to be attachments. This information will need to be included. And they're only going to be able to gather it from you. And they're going to probably more than likely use legal staff to gather that information. That's why I say if you could gather it on your own as this incident is moving along and keep it for yourself, you can use that for your own purposes if you have the savvy and the know-how, or you can gather that and be ready for legal counsel and be helpful to yourself.